Hello friends, I am Arpit and I am here with today's analysis. Today is 22nd of December and we are going to deal with three very important topics which are in news. These three topics are the three criminal bills which are there in the parliament. Some have been passed by both the houses, some are under deliberations. Now since the winter session has ended, so it is for sure that these bills are not being adopted or not being passed in the current ongoing session which has just been concluded. The first is the Bharatiya Nyaya Sanhita Bill 2023. The Bharatiya Nyaya Sanhita Bill replaces the Indian Penal Code IPC of 1860. Provisions with respect to terrorism, mob lynching, circulation of fake news, all these have been introduced and this IPC has got a new avatar. Whereas some old provisions have been tweaked, like with respect to minimum punishment, the provision has been tweaked. The provision with respect to, I would say, homosexuality or section 377, they have been removed totally. There are certain contentions in the bill which are also, making this bill controversial. The opposition has made it clear that if this bill gets passed, they are going to the Supreme Court by, taking this bill and challenging this bill. The second is Bharatiya Nagarik Suraksha Sanhita Bill. That is, the Code of Criminal Procedure or Criminal Procedure Code CRPC. That is going to be replaced by this. CRPC deals with arrest, penalizing and provisions of bail for the convicts. The process or the procedures followed in all these steps are according to the CRPC. So that is also under consideration. That is also being changed. Some provisions with respect to this CRPC are being changed and being given a new color. And third is the Bharatiya Sakia Bill 2023, which replaces the Indian Evidence Act. Now, this Bharatiya Sakia Bill 2023 is making electronic evidences as primary evidences, whereas electronic evidences were considered as secondary evidences in the older law, that is the Indian Evidence Act. This and more such provisions are there in the Bharatiya Sakia Bill. Now, the need for bringing these three bills collectively was that, the times have changed, the natures of crimes have changed. Like, for example, organized crime, which is considered to be a new age crime, it has been brought under the ambit of, the Bharatiya Nyaya Sanhita Bill, that is the new IPC, we can say, which was earlier not there. So these have been the various, I would say, or the primary reasons for introducing these three criminal bills. So let's get started with the first and we'll get to know the details of each. The Bharatiya Nyaya Sanhita Bill. This is replacing the Indian Penal Code IPC. The new bill seeks to include issues like love jihad, terrorism, organized crime, mob lynching and such like. These issues were not included in the older IPC. However, there was a separate law for terrorism, UAPA, which defined what terrorism is. But now under IPC also terrorism has been defined. Means IPC means the Bharatiya Nyaya Sanhita. This is the new IPC. Mob lynching was not defined anywhere. Although the Supreme Court in 2018 said that, laws should be made specifically with respect to mob lynching. But unfortunately, only a few states has made laws with respect to mob lynching. The center has not made. But now the center has included provisions with respect to mob lynching in this new IPC or the Bharatiya Nyaya Sanhita. Changes in provisions related to sedition, fake news and mandatory minimum sentences have been also done. Sedition, fake news, minimum sentences were there already existing, but changes in them have been done. Now, promise to marry. The first provision which we are picking is love jihad. Now, if any, youth deceives, or by deceitful means, indulges into any sexual activity with a female, then that youth will be punishable. And this is what was happening in love jihad. Actually, love jihad is kind of an informal term which is gaining more and more prominence, where members of the minority community, they used to purposely fall in love with the members of the majority community, and with this pretext of having sexual intercourse with them or marrying them. The main aim was to either malign the image of that, I would say, individual, or just try to marry and bring that individual in the minority societies, and have families with them or procreate with them, so that their population increases and the majority's population reduces or gets stagnant. That was the main aim behind love jihad, or that was love jihad actually. So the Bharatiya Nyaya Sanhita introduces clause 69 that seems to ostensibly tackle the love jihad narrative by criminalizing deceitful promise to marry. Now, there were also cases where members of the minority community, or we can say community X, they were, giving this deceit to the individuals of Y community that they will marry in future, and for that purpose, they wanted to have sexual intercourse with each other. But, when it came to actually marrying, they denied. So, it was like this. What does deceitful mean? This has also been explained. Deceitful means shall include the false promise of employment or promotion, inducement or marrying after suppressing identity. That is a deceitful mean. Next is mob lynching. Mob lynching, the incidences of mob lynching have increased in the past few years. 2017 saw, increased number of cases of mob lynching throughout the country. The Supreme Court at that time was very much vocal on this. Mob lynching simply means when mob, in Hindi this simply means bheed, or a group of people, they, in order or in the pretext of administering justice, they lynch someone or they kill someone. Lynching means to kill. So this has been defined in IPC and made an offence under this new Bharatiya Nyaya Sanhita. Basically, when a mob of 5 or more individuals commits murder based on factors such as race, caste, community or personal belief, the provision has punishment that extends from life imprisonment to death. In its earlier version, actually this bill was introduced in August. Then it has been again reintroduced. That is why it is being termed as BNS second. So in its earlier version, the bill had proposed a minimum sentence of 7 years, but this was brought at par with murder now. That is why, for murder, the punishment under IPC is this, life imprisonment or death. And when 5 or more individuals commit murder, so they should also be given the same punishment. So now in the second provision, which has been retabled by the government, this has been brought at par with murder. The Supreme Court in 2018 asked Centre to consider separate law for lynching, but it has not been made. Now next is organized crime. Provisions with respect to organized crimes have also been accommodated. Now organized crime is any crime of financial nature committed by an organization which are maintained in a particular hierarchy. So when an organization is indulging in any crime, and that crime is financial in nature, like kidnappings, extortions, betting, gambling, that is called as organized crime. Now earlier there was this major drawback that there was no separate law by the center dealing with mob lynching. Now also it is not there. Provisions under IPC are there, whereas certain state governments had their laws with respect to organized crime. For example, Maharashtra's MCOCA law, which was one of the famous laws for tackling organized crime, that is Maharashtra Control of Organized Crime Act 1999. This is a state law with respect to organized crime, but the center had no law with respect to organized crime. Now, provisions with respect to organized crime have been included in the Bharatiya Nyaya Sanhita, BNS. Now, in the new legislation, punishment for attempt to commit organized crime and committing organized crime is the same. If you are attempting to commit or you have committed, punishment for both of these cases are the same. But a distinction is drawn based on whether a death is caused or not by the alleged offense. Now, if your organized crime is leading to death of any person, then in that case, punishment will be severe. For cases involving death, the punishment ranges from life imprisonment to death because you murdered someone. But where there is no death involved, a mandatory minimum sentence of 5 years is prescribed. The law, this Bharatiya Nyaya Sanhita has also defined petty organized crimes. What are petty organized crimes? Theft, snatching, cheating, unauthorized selling of tickets, unauthorized betting or gambling, selling of public examination question papers. They have been included as petty organized crime, and for those also the punishment is 5 years depending on case to case. Next is terrorism has also been added, and this is something which is, I would say, one major step taken by the government. Although there already exists a law which defines terrorism in India, that is Unlawful Activities Prevention Act, UAPA. But there was no definition of the word terrorism in IPC. And when I talk about definition of terrorism, so terrorism is one such, I would say, word which does not have a universally accepted definition. There is no universally accepted definition of terrorism. So this is like this. But yes, countries have their own definitions. Likewise, India has one definition of terrorism under UAPA. The second definition is here. And what is the definition of terrorism here? An act that intends to threaten the unity, integrity and security of the country, intimidate the general public or disturb public order is called as terrorism. Very broad, I would say, definition. Importing large parts of the language in defining terror activities from the stringent Unlawful Atrocities Prevention Act has been done. It is unclear how both UAPA and Bharatiya Nyaya Sanhita will operate concurrently when cases with respect to terrorism will be there in place. Then attempts to suicide. Now if one attempts to commit suicide, then that will also be punishable. And particularly, a situation has been defined in this domain, that is whoever attempts to commit suicide with the intent to compel or restrain any public servant from discharging his official duty. Now, how suicide and this restraining any public servant from discharging official duty are being connected? This provision could be invoked to prevent self-immolations and hunger strikes during protests. So if protests are going on and if someone's threatens that I will blow myself up or I will die by hunger, doing hunger strike and activities like this they do, then they will be punishable under this Bharatiya Nyaya Sanhita. That is where the connection is. Then next is gender neutrality. This is something which has been a positive or a welcome step in the Bharatiya Nyaya Sanhita. The BNS was it has tweaked certain laws to accommodate the, I would say, gender neutrality aspect within this, particularly laws or provisions dealing with children. Now, the offences dealing with procreation of a girl, especially for a minor girl, for illicit intercourse, 366A of IPC defines this, has been made gender neutral. Means not only procreation of a girl, but procreation of any child, girl or boy, for intercourse if you are taking that particular child. So you are forcing intercourse on them, you are brainwashing them, forcing intercourse on them because they might not have any idea about what intercourse is. So it is like this. For offences dealing with kidnapping of minors, the IPC section 361 prescribes different age limits, 16 years for male and 18 years for female. This was in the earlier IPC. But now the BNS makes it 18 for both. Then for adults, the offense of outraging the modesty of women, 354A of IPC, and voyeurism, 354C, now has gender neutrality for the accused under BNS, which means women can also be booked under this law if modesty of a man or a male is being challenged by anyone, a woman or a male. So that can also be there. So these provisions clearly define that this has become gender neutral. Then next is fake news. The IPC currently contains section 153B, which deals with imputations, assertions, prejudicial to national integration. These all things lead to hate speech being spread. And this hate speech can create disharmony or feelings of enmity or hatred or ill will. Now, BNS introduces a new provision which criminalizes publishing false and misleading information. So, this fake news leads to basically hatred in the society. This leads to disturbances. All these have been tackled by the new Bharatiya Nyaya Sanhita. Now, sedition. Sedition is when you go against your government and start talking against your government. So it is like this. So earlier provisions with respect to sedition, that is 124A of IPC, was being removed in the earlier Bharatiya Nyaya Sanhita. But it has now not been removed, and the distinction has been made between Rajdroh and Deshdroh. If you are saying anything against the government, that is Rajdroh. You are entitled to say, because we live in a free country. Freedom of speech and expression is there. You have all the rights to criticize the government. But if you are saying anything against the country which is harming territorial integrity or sovereignty of the country, then you will be booked under provisions of sedition, because that is Deshdroh. So, the BNS introduces offences under a new name and with a wider definition. Apart from a name change from Rajdroh to Deshdroh, the new provision brings under its sweep aiding through financial means acts of subversive activities and those encouraging feelings of separatist activities. They will be understood as anti-national or anti-country or Deshdroh, and then you will be booked for sedition. So it is like this. Next is mandatory minimum sentence. Now earlier, for an offense like murder, the mandatory minimum sentence was a death sentence. But in 1983, the Supreme Court, removed this provision, said that, this is crippling our, I would say, strengths. What if we do not want to give death sentence? We want to give life imprisonment. So we can do that as well. So that minimum mandatory death sentence was removed in 1983. Okay. So section 303 of IPC prescribed for a mandatory death sentence in case of a murder, but that was removed. Now BNS, what has BNS now done? BNS has now tweaked this provision to prescribe a punishment of death or imprisonment for life. Life imprisonment or death. We've been seeing at it mob lynching, murder. You go for life imprisonment or death sentence. But life imprisonment is what? Which shall mean the remainder of that person's natural life. Generally, life imprisonment means 7 years, 14 years, 21 years. No. Now, for the remainder period of your life, you will be in the jails. That is imprisonment for life. In several other provisions, mandatory minimum sentences are prescribed, while the prescription of a minimum sentence limits the scope for judicial discretion and arbitrariness. It is seen to be unfair to the convict also. Now, this was the case of murder which we discussed. But for other convictions also, there is this minimum mandatory sentences which have been defined. But defining minimum mandatory sentences for offences actually cripples the rights of the convict. What if, someone has done or committed a crime in good faith or in order to save himself or herself? Or what if someone has committed a crime and that person is the sole breadwinner of the family? The courts will be bound to go by minimum prescribed, I would say, punishments. That is something which is, I would say, not called for. Courts can be lenient or could have been lenient earlier, but now they would not be lenient. Now, deletions from this new IPC, or I would say Bharatiya Nyaya Sanhita, or older IPC, what deletions have been done from that? Unnatural, not new, it is from old IPC only. From older IPC, what deletions have been done, and these are not part of the Bharatiya Nyaya Sanhita. Unnatural sexual offense. Actually, the entire section 377 has been striked off and it is not there part of Bharatiya Nyaya Sanhita. But Supreme Court in 2018 only striked off the homosexuality. Means homosexuality, which was earlier illegal when it was included or it was part of section 377, was made legal by the Supreme Court in 2018. But other forms of unnatural sex were still illegal. But the entire section 377 has been removed now. So, this is something which is actually critical of this law. Then adultery, the offence of adultery, which was struck down by the Supreme Court as unconstitutional in 2018, has been omitted under the BNS. It is not there. Thugs. The IPC under section 310 criminalizes those who have been habitually associated with any other or others for the purpose of committing robbery or child stealing by means of or accompanied with murder, and labels them a thug. This provision is criticized for attaching colonial notions of criminality for certain tribes. This has also not been included. However, child stealing or all these things are there in other provisions. But the provision of thugs has been deleted. So, these are the deletions. Now, criticism of this bill. The first criticism is that the IPC provides protection from prosecution to a person of unsound mind. Protection is there for a person of unsound mind. The BNS, in IPC it was there. BNS changes this to a person with mental illness. The definition of mental illness excludes mental retardation and includes abuse of alcohol and drugs. So means if a person is under the influence of alcohol and drugs and at that time any crime happens, the BNS has accommodated this, that the person will be punishable. But yes, if a person who is mentally retarded and then commits the crime, then that is not included. This is something which is there. Then the definition of terrorism includes an act that intends to intimidate public order, which is very, very broad. So if someone is protesting against the government and for in that situation any violence happens, then that person also can be booked under terrorism provisions of this BNS. Several offences overlap with special laws like terrorism, UAPA here. In many cases, both carry different penalties or provide for different procedures. Now, what will happen? Since this anomaly is there or these differences are there, so it will be difficult for the judiciary to interpret under what I would say IPC or those special laws that person has to be convicted. So this is something which is creating a lot of confusion. BNS omits section 377 of IPC entirely. 377 dealt with sexual activities or illegal sexual activities. However, Supreme Court in 2018 only said that homosexuality is allowed. That part of section 377 was removed by the Supreme Court. But now the entire 377 has been removed. So this is something which is kind of unacceptable, and these are the points of contention in this particular bill. The next is Bharatiya Nagarik Suraksha Sanhita 2023. This is going to replace the CRPC, that is Criminal Procedure Code or Code for Criminal Procedure. CRPC provides for procedure of arrest, prosecution and bail. in what ways the person will be arrested, what ways prosecution will happen, in what ways bail will be provided. All these are there in CRPC that has been now replaced by Bharatiya Nagarik Suraksha Sanhita BNSS. Now key provision, BNSS mandates forensic investigation for offences punishable with 7 years of imprisonment or more. So any offence which invites imprisonment of 7 years or more, for those kind of offences, it is mandatory that forensic investigation happens. It is completely mandatory. All trials, inquiries and proceedings may be held in electronic mode. Production of electronic communication devices likely to contain digital evidence will be allowed for investigation, inquiry or trial. This was not there earlier. If a proclaimed offender has absconded to evade trial and there is no immediate prospect of arresting him or her, the trial can be conducted and judgment pronounced in his absence. So this is also there. Along with specimen signatures or handwriting, finger impressions and voice samples may be collected for investigation or proceedings. Samples may be taken from a person who has not been arrested also. So these are there with respect to arrest, prosecution, bail. Now criticisms of this is that the BNSS allows up to 15 days of police custody, and which can be extended to 90 days, 40 days, 60 days or 90 days also. This is being heavily criticized by the opposition that you are giving extraordinary powers to the police. Actually, this police custody duration, there cannot be bail in this duration. It is clear. So for minimum this much duration, a person, if is arrested, can be there under the police custody without bail being granted to that person. The power to attach property from proceeds of crime does not have safeguards provided in the Prevention of Money Laundering Act. Prevention of Money Laundering Act, if someone is involved in money laundering and it is suspected that the person has brought directly or indirectly certain properties from that money, then that property has to be attached, means it has to be sealed. Here also attaching property or sealing properties provisions are there, but it does not have safeguards like they are provided in PMLA. Then CRPC provides for bail for an accused who has been detained for half the maximum imprisonment. Now in earlier CRPC, what happened? Let's suppose I committed a crime and the maximum punishment for that crime is 5 years. But the courts have granted me punishment of 2 years, less than half of the maximum punishment. Then I can easily apply for bail and I will get bail. It was like this. So, but now the BNSS denies this facility for anyone facing multiple charges. As many cases involve charges under multiple sections, this may limit such bail. The use of handcuffs is permitted in a range of cases including organized crime, contradiction or contradicting Supreme Court directions. In all these cases, handcuffs can be there tied on the hands of the criminals. And the last is the Bharatiya Sakia Bill. This Bharatiya Sakia Bill is going to replace the Indian Evidence Act. So this Evidence Act was also a pre-independence era act of 1872. However, this retains most of the provisions of the Indian Evidence Act, but yes, there are some changes also. Now, the IEA provides for two kinds of evidences. First is documentary and oral. So, evidences, two kinds. One is documentary and one is oral. Documentary evidences includes primary and secondary. So I'll write documentary over here, oral over here, and documentary over here. So in documentary, primary and secondary. Okay. Now, primary is the original document and secondary is that proves the contents of the original, which backs the original document. This is the meaning of primary and secondary. Now BSB, that is, retains the distinction. The distinction is retained between primary and secondary, but it includes electronic records in the definition of documents. So it is like this. Here, electronic records are included as documentary evidence. Under IEA, electronic records are categorized as secondary evidence. These electronic records under the Indian Evidence Act were over here, secondary evidence. But now, under this Bharatiya Sakia Bill, it classifies electronic records as primary evidence. So, electronic records have been moved from here to here, secondary to primary. So, it is like this. Now, it expands such records to include information stored in semiconductors or memory, semiconductor memory or any communication device, smartphones, laptops, pen drives, hard disks, etc. etc. Under the IEA, secondary evidence may be required under various conditions, such as when original is in the possession of the person against whom the document is sought to be proved or has been destroyed. However, the BSB adds that secondary evidence may be required if the genuineness of the document itself is in question. If the genuineness of the primary evidence is in question, then the secondary should be required. This is what this new law states. Now, issues with this new law. The Supreme Court has recognized that electronic records may be tampered with, but BSB has made it a primary, I would say, documentary evidence. Evidence two types we saw, oral and documentary. Documentary further of two types, primary and secondary. Earlier, electronic evidence was secondary, now it has been made primary. But Supreme Court has recognized that electronic records may be tampered with, but still it has been made primary documentary evidence. This is one such criticism with this particular law, and there are no safeguards to prevent the tampering and contamination of such records. Now, under the IEA, that is the older law, a fact discovered due to information received from an accused in police custody may be provable. But BSB retains this provision. Now, if someone is there under police custody and police, makes that person, speak anything and notes it, that can be counted as an evidence. But police could have, coerced that person to speak out. Probably that can be false also. The BSB should have addressed it, means the new law should have addressed it, but it has not addressed it. Means in the BSB also, the statement given by any suspect to the police can be counted as an evidence. The BSB retains this provision. Courts and committees noted that facts may be discovered in police custody by coercion and without adequate safeguards. IEA and the BSB allows such information to be admissible if it was obtained when the accused was in police custody, but not if he was outside. The Law Commission recommended to remove this distinction along with the courts, but it has not been removed. This is one such criticism of this particular new bill. And this is it. We have completed the 3 new criminal bills which you need to understand. The broad contours of this bill have to be understood, and along with the criticism of all these bills, because UPSC can ask such kind of questions in mains. Less likely in prelims, but yes, more in mains, more chances in mains of these kind of provisions to be asked. So those need to be accommodated. And I will be meeting you tomorrow now with more such informative news pieces. Till then, you guys very well know what to do. Keep studying, keep reading, keep writing, and most importantly, keep revising. Namaste. Jai Hind.